Good afternoon, everyone. Thank you so much for making the time to join our little party here of Open Government Advisory Group. We really appreciate this from you. So I'm going to call to order. The time is 1:07 p.m. and I'm calling this meeting of Open Government Advisory Group to order. We're meeting virtually via Teams to afford increased attendance and flexibility. So that's how we're probably going to do it for a while. And if anybody wants to do it in person, we can do it in person, but we probably won't get as many people. Just let us know. This meeting is being conducted in adherence to District of Columbia Open Meetings Act and is being recorded. First order of business is to establish a quorum to conduct business. I will conduct a roll call. Please say present. If you're filling in for someone, just say present, filling in for so-and-so. So I'll start with me, Vanessa Natale, Chair, Executive Office of the Mayor Designee, present. Cherie DeBerry.
Cherie, you're on mute, sweetheart.
Put the camera on. Present, designee for Nicole Allen, Office of Open Government.
Thank you, Cherie. Renako Alsop from OAG.
Hi, this is Megan Browder, present, filling in for Renako Alsop.
Thank you, Megan. We're going to steal you forever, but we'll introduce you later. Robert Becker, representing the public. Okay. Helen McClure.
Present.
Van Freeman. We haven't seen him in a while.
Yeah, we haven't seen him.
Lindsay Apaya, Michelle Vanneman, or Danielle Creek. Julia
Michelle
Hudson.
Vanneman's present.
Thank you, Shelley. Thanks for coming in at the end. I appreciate it.
Sorry, proved to be late.
No, thank you for doing this. Julia Hudson.
Present.
Thank you. Let's see. Catherine Pettit. Oh, we couldn't hear you, Catherine.
Oh, present.
Thank you, Catherine. We've missed you. Earl Rodriguez.
Present.
Thanks, Earl. Erica Satterley, I think she's on vacation.
Yeah, she's out.
The better Vanessa Carrero.
Present.
Thank you, Vanessa. Let me see. Kyle Spears. David Sang.
Present, Madam Chair.
Thank you. Zach Walter.
Present.
Thank you, Zach. How many people do we have, Julia? I'll leave you up to the counting.
Yeah, Madam Chair, we have 13 attendees.
Okay, there are 13 members present and we have a quorum. Thank you to conduct business. So we need to adopt our agenda. It's been posted on the website. Does anybody have any additions, comments? No problem with that. Anyone? Any changes? Hearing none, I move that we adopt the agenda by unanimous consent. Any objections? Hearing none, the motion passes and the agenda is adopted. Okay. Okay, so are there any other public witnesses, friends? I see, we got Catherine, Bob, Earl. I don't think anybody else has jumped on. Okay. I've also like to introduce Megan Browder from OAG. She is nice enough to get the short end of the stick and have to represent OAG on this, but I told her it's the best group and we're the best looking. So Megan, can you just say hi to everyone and tell us what you do over there?
Sure. Hi, everyone. Good afternoon. My name is Megan Browder. I'm senior counsel to the AG here at OAG. So I'll be taking Renako's place.
Thank you. She's super smart and the real lawyer in the room. Okay, so thank you guys again. I just wanted to tell you that I put together kind of a draft advisory opinion. It's kind of bare bones. So Julia's going to put it up and then we're going to send it out to everyone. Also, I just want to tell everyone, so I started putting together what we talked about in the last meeting. So I had to unfortunately listen and look at myself on the recording. And I just want to apologize again and again for my New Jersey accent. And apparently my part is always crooked, which I noticed on the other video. So, please forgive me for that, but I couldn't take watching it. But I took the notes from it. We talked a lot about how we can update or make more practical FOIA and our process and what we'd have to do to get it. So Julia's going to open that up, and then we're also going to send it out. And
Okay,
this
so
is,
we have a copy. I'm sorry, Madam Chair. We do have a copy already in the chat. I
Oh, we
am
do?
trying now to open
That's
up
okay.
the document so that we can do a share screen.
Oh, I see it. So we scroll up to your name, OGAG advisory. Okay, and then it'll come up, and then, but you can't see the video, but that's
I'm
fine.
working now. Okay, can everyone see?
Oh.
Is it on your screen now?
Yes,
Okay, great.
you may have to make it bigger because I can't see it.
Okay, let's see.
I
Oh,
like
that's
how you're
me.
there,
That's
Julia.
me.
It
Hang
looks
on.
good.
No, that's me. Okay, let's see. Let's see if it'll allow me to do that.
All right, never mind. I mean,
Is
I
that
have a
better?
copy of it here.
Okay. I don't
So
know.
everyone,
Is
I
it still
tried,
up? Can you see it?
I can see it, but you're in front of it.
Yeah, I don't know what happened. I'm sorry. I'm not the most savvy. I
No, I
apologize.
kind of like it. Like I want you to point at things like Vanna White, like
No.
just point at okay, there you go.
That's
All
not-
right, technical difficulties handled. So I went through, listened to myself and all of us talking, and it was actually kind of fun. And I tried to take notes the best I could, and I broke it down. Now, keep in mind, this is not just my opinion. This is for everyone, and I want you to slash and burn, add, edit, as much as you need. I just want to be the first Open Government Advisory Group to actually give a deliverable to the mayor. So we start out, the regular purpose, the rationale. A lot of you deal with FOIA more than I do. So if you want to put in more rationale, anything, just to make it look like we know what we're talking about, or some more practical reasons, we'll do that. So I found a few that I have titled non-controversial. Now, that's kind of how it was when we talked, but if it's controversial, I'm just trying to think of the ones that maybe for our first opinion that we can get out, maybe we start with non-controversial so it doesn't take forever. And then for the next round of meetings, we can talk about the stuff that may be controversial and go back and forth. Agency response time. How does everybody feel about, currently we have 15 business days and, let's make it match the feds to 20.
Well, I already said that I have no problem with adding 5 days, but I think that makes this the only non-controversial one on the list.
Okay, well, well, then I guess I was being cocky by saying the other ones were, but that's
Good
fine.
for you, Bob.
Thank you, Bob. That was the easy one. Okay, I did throw in case, I would appreciate everyone or whoever to put in the rationale. I did throw in this very recent news article about the federal, about FOIA backlog because of FOIA, because of COVID. It's kind of interesting. So you may throw that in. And then additionally, because half the time I don't know how this, I assume this would be a statutory change because I don't even know if we have regs. We don't have regs. Do we, Bob?
There are regs, but this is a
Oh, sorry,
statutory
regs.
issue.
Okay, so whatever you think we need to change it, change the reg. So that's good. But if anybody is like not happy with this, just when you get your copy of this, put in what you think, and we can discuss it at the next meeting. The number 2 is one that I really thought made a lot of practical sense. It's a timeline negotiation between the requester and an agency, which some of us decided, and said, this is being done at the agency level anyway, and we kind of want to memorialize it. Also, I think Vanessa brought up, because of reporting requirements, it still makes it look late, even though we agree on doing different timelines. Woody, how do you guys feel about that? I mean, I know we're going it over again, but like, let me know if it's non-controversial.
As I said, this is not something that I want to see in the statute. Okay.
Okay.
I think the statute allows this to happen. I think if you're having a problem because of the way it looks in the reporting, then maybe you need to change the reporting system. How you report things.
Okay. So we can make that maybe thing, adding a reporting requirement.
Well, there are reporting requirements in the statute.
Yeah.
It shouldn't be part of that. It's maybe, something that says, okay, we didn't make the statutory deadline, but we didn't make it because we negotiated a different deadline. And that's a checkbox on your reporting form, not a statutory.
Yeah, I think we need some Octo input here to, I think for those of us who are not as tech savvy, that may sound like a small change to FOIA Express, but I'm not sure I want to say that it is, given that I'm
Okay.
out of my depth in IT.
Thank you, Vanessa. That makes sense. I think Steven's on vacation. He's allowed to go, but we'll get him later for this. I would also think that maybe the public would think this is a way for the government to kind of dodge our responsibilities by like if we keep having negotiated timelines. Is that
It
something?
happens all the time. It happens all the time in federal. It happens all the time here.
Okay, so it's not that. Okay.
And I think actually going one step further, Vanessa, I'd say if we went for a statutory change here, we might be saying that what we've been doing is inappropriate. And I'm not sure. I think we're all on the same page that negotiating is fine. So I think I'd support some more conversations with Octo to figure out how to just capture this from a reporting requirement without necessarily needing to do the lift of a statutory change.
Okay, maybe whenever you have time, you, Julia, we'll have a call with Steven and kind of see if that can be done. I think that's a really, really good suggestion. I didn't even think of that. Anybody else? Good, okay. Number 3, what about tolling? Of, the timelines about, when we're waiting, we're trying to start the conversation with the requester. What about tolling?
I think that's sort of a thing that happens all the time. I think David said that when they respond saying we need more information, they give a deadline to the requester to get back. Isn't that what you said, David?
Yeah, we do generally, and it is to your earlier point, Bob. There is sort of, for the most part, sort of the back and forth with the requester in terms of these timeframes. I do, so I agree, Bob. I think that with respect to the first sentence, that it basically is happening already. I do agree, though, that there should be some. I support a deadline if we don't hear back from the requester.
But I'm putting that in the statute is a little bit weird, quite frankly.
I don't know why it's weird.
I put everything down as statutory.
We have deadlines in the statute already. Bright line.
Well, yeah, but okay, but the so you have a statutory deadline, and the requester hasn't. Again, the reason it's problem is because of the reporting. It's not a problem under the statute. You respond, you say okay, or you say in your question to the requester, we will close this if you don't respond to us quickly. We will send you a letter that says at the end, we could not respond, we could not fulfill your request because you didn't give us the information.
I'm fine with that response, Bob, but what's the statutory authority to close it out? That's what we're looking for. It's sort of the statutory authority that will allow a government agency to say, look, we've asked you for information. Here's 30 days. It doesn't have to be 30 days. I mean, we could talk
I
about.
I cannot think of a single state or a federal transparency statute that does that. They do it in regulations maybe, but they don't do it in statute.
Okay, that doesn't mean that we can't do it.
I think that there's a possibility for abuse in those situations, and I'd prefer to see it not in the statute.
Okay, I'm trying to understand. So what is the abuse?
You know, it's if an agency doesn't want to disclose the information, it poses questions, okay? And that's a way of delay. That's a way of avoiding meeting the deadline.
Well, that's
That's
like
the
no
kind
good
of
faith. That's a bit
that's-
like that's
that's the kind
assuming
of-
bad. I get it, but that's assuming bad faith on part of the agency, and I don't think the statute thinks about that. I mean, if that is the case, that's not good. Hopefully, that would get fixed later. Isn't that what you think, David? I mean,
Yes, I mean, otherwise, Bob, we send those letters out to close it, but but it's basically because we never heard from you, right? We're waiting
Okay.
30 days. We heard nothing from you. It's open. We're closing, but but it's basically because that's as far as we could go, but without statutory authority.
Okay, yeah, and I think that's what's going to happen. I just have a problem with creating a situation where it can be used in a different way, especially when there are no penalties in the statute for that.
Okay, I mean, certainly, I have a problem too with bad faith.
Yeah,
right.
With anybody who is engaging in bad faith to forestall providing information to which the public is entitled. No question. And
let's talk about like bad faith and maybe penalties, like small p for penalties for our next round of stuff. Like that'll be a bigger topic, and we
Okay.
can talk about
Okay.
what we think about that. Shelley, I see your hand. I see your yellow hand up.
Yeah, I like that it provides consistency. Then all agencies will have the same rules and new people coming in will know what to do. I actually would make it 20 days, the same that we have to respond. In promulgating rules recently to the board, that's what we did. We made it all consistent. I mean, they were regulations, but there's nothing prohibiting it by statute. And I think the consistency will actually help to avoid any kind of bad faith that may or may not even be out there.
Bob, you're lighting up.
I'm not sure why. I'm just sitting here looking. I don't know.
Okay,
I don't
that's
know.
okay.
I'm not sure what that was about. How's that?
Yeah, and I like the idea of we put it down in whatever it is, statute or a regulation, which as you can tell, I clearly have no idea about. Just for the people that follow us, a lot of times if you're doing FOIA, you just have the statute right there or the regs, then we can kind of have future consistency. So that was a really good point, Shelley. We may have you help us with maybe our regs or rules. And I believe, who was it last week? Was it Erica? Maybe talking about she does the same thing as David does. If we don't hear back, we close. And then maybe we were talking about, is that something, do you think, I mean, we should just have a template and then, people like agencies can use that, or we just leave it up to the agency. So that's kind of stuff to think about. Oh, Shelley, you're still hands up. Can't hear you now.
Sorry, I'll put it down.
Oh, but you're always, yeah, just jump in then. But
I think I put it down. I'm happy to help with the regs. I've done a lot of regs for the board.
yeah, thank you. Okay, so
Vanessa, can I just add one point? Which
of
is
course.
with Bob, when we close it out because we haven't heard, our position basically is that the requester has abandoned the request.
And you
that-
paper the record so that if there's an
And
appeal,
we do, yes, exactly.
But that might be good to kind of teach the other agencies to do that kind of stuff. But wait 1 sec, let me shut this door. You know, my voice is like an intercom. I keep forgetting I had to shut the door. Okay, so number 4, this was something I had no idea about. When the feds respond to the request, they say, and this is just me, just saying what I thought I heard. These records, okay, we can do this, and these are the records we'll produce. And then they can kind of produce them as it goes, or not at the same time as, the 20 days or the deadline. So the initial response and production at a later date. And I remember Renako said that's not in our FOIA world.
and it's not in the federal either. I think that's a misreading of the federal statute. Federal agencies are required to pretty much to acknowledge the request quickly.
Okay,
But that doesn't change the disclosure deadline.
I get it.
Okay, and they may work out a different disclosure deadline, or they may work out a rolling disclosure deadline, but the response to the initial request, this is after I think the most recent federal amendments to the federal statute, but a lot of them just send a postcard that says, we got your request, we're aware of the deadlines and we are going to do our best, we'll let you know more. But that doesn't change the deadline.
Okay. All right, so we'll change that one or take it out. And thank you for explaining that. I think we do. I mean, the agency I was at, we've done, we received it. We'll get back to you, like just that, so they don't have to wonder if we
FOIA
got it.
Express does that automatically too. It sends out an automatic message email
Okay.
to the person saying this was received on such and such a date.
Oh, thank you, Helen. Again, people that really work here, so that's nice, which is unlike me. So here's the one that this is my baby, number 5. And I haven't had this baby like just now. This is something that has bothered me and I've seen abused from when I was at an agency. And I think when I was at OAG. I would like us to discuss creating a new exemption. FOIA requests from individuals' attorneys in litigation with the requested agency. Someone from my office, Andrea, just did a quick look around to see what the other states do. So this is something, we would have to flesh out. Like one is very narrow, others are not. How do people feel about this in general? Am I being is this like Vanessa's martial law with exemptions, or is not crazy? Like, what is this? Like, what do you think?
Well, I think, Vanessa, I think that the problem here is your concern is that litigants in litigation with the district should not be able to get records under FOIA that they couldn't get through discovery. But if let's say there's a contract out there that the district has with some contractor, and the contractor's in litigation with the city over the contract, perhaps they shouldn't be able to get the records from under FOIA and circumvent the discovery process. But I'm a resident of the neighborhood affected by the contract. If this litigation goes on for years and I want the information because of something going on in the neighborhood, why should I be denied access to that information? It's public record. I'm not benefiting in any way from FOIA in a way that I couldn't benefit by discovery.
Right. Bob, in your hypothetical, the resident is not a party to the litigation. Is that right?
Right, correct,
Okay.
correct.
I agree.
It sounds like the California part that cited, this part 3, that it had an interest in not disclosing until after the litigation has finalized. So it sounds like it could be crafted such that it doesn't allow you to get an end run around discovery. Like
Okay.
the things, something that's public record that doesn't have an impact on the litigation would not be exempt.
But what I'm saying to you is, I don't care whether the record has some impact on the litigation for the litigants. I'm just a resident of the city, and this contract affects my life. I want the information. It's public record. The fact that it's part of somebody else's litigation shouldn't deprive me of access to the information.
I agree.
Yeah, that's the
So
rub
what I'm
there.
reading is that it's the litigant who can't get it.
Yeah.
It doesn't say anything. It says what does it say?
I just said
To which the
individuals,
public
meaning
agency is a
litigants. I
party.
should have said
Yeah.
litigants, yeah.
Yeah, I think if it just says litigant, then I think that
I mean, the
would solve
district
it.
has interpreted our exemption as basically putting whatever that information is off limits to everyone because there's litigation pending. And I think that's wrong.
Yeah, I'm not sure that we, speaking for my agency, that we would go that far. I think our issue has been with respect to litigation, where it's clear that the litigant, or more precisely their representative, is trying to do an end run around the litigation to get the records. And in some cases where a judge has specifically disfavored discovery. So we would support a litigant focused exemption.
Yeah, and I guess we'll have to look at like cases and like flesh this one out. I mean, I was just being, like I said, like cocky by putting this in as non-controversial, but this is something we need to flesh out for our second, like our next or second advisory opinion. But I think it's needed because the problem and the practicality that I see is it makes a bunch of people working doing the same thing. So a lot of it may be attorney-client or work product.
Well, if it's work product, it's not going to be disclosed to anybody
Right.
because it's exempt as underprivileged.
But if
So-
they don't ask, if they're in litigation with the city or the agency, and it's already been told that this is work product or whatever it is, and then they do an end around and the FOIA person does it and doesn't know about that. I mean, I'm just thinking about bigger agencies, and yes, hopefully the lawyers know all this, but our lawyers that represent us, that's a whole other agency. They may not know. I mean, it's that kind of stuff. Now, I also don't have a problem with potential plaintiffs, FOIAing to find out what happened in a thing to maybe build their case on. That's totally fine. I mean, that's true, I think, open government to see what they did and if you've been hurt by them. But this is something I would like to, we can think about it more. And if anyone, once we send this out, please just add on what you thought, or if you have a case, or if you think you have a way that you think this would work in the district, changing maybe what some of the other states have done. Does that sound okay? Oh, wait, it says here, and then there's arbitration, applicable discovery. Okay. And then number 6, we talk about the FOIA reporting, negotiated timelines, and properly, Vanessa pointed out that's a FOIA Express thing, so we're gonna look at it that way. And that'll be part of our homework. So here's some what I would call controversial recommendation suggestions, and this can be for our next round, and if you all have others that you're thinking of, please put them on or put something in more non-controversial. I believe, Renako fleshed out a lot about, and Bob actually, about the law enforcement, the endangerment exemption, everybody's face and name that's in the video, opening up to victims or that kind of thing. And I believe Kyle was the one who said DOJ's official policy is presumption of openness, but maybe we need to look at that. I would say that, Bob made a good point about, what's going on in Baltimore, that they just do they show everything and then what do they do in Baltimore again, Bob, if you don't mind?
Okay, with body cam video, okay, in DC, the MPD very heavily redacts. They redact even cops' faces, badge numbers, and stuff like that. Cops in uniform. In Baltimore, if something has happened on a public street, if it happens in a private house, I don't know what would happen. I just, as a test for something we did, requested a video of an incident that happened on a street on a Friday afternoon during rush hour. I got unredacted videos, showed everybody that was there. And that's consistent with American privacy law. Nothing that happens in a public place is private. And so MPD takes a lot of time, claims that they want a lot of money to do things that they don't really need to do. And their version of the privacy exemption is very expansive and it needs to be narrowed. And I think that the district has gone way overboard.
And I assume there's a lot of litigation about this too.
Well, certainly there's been legislation about the body cam video to open more of it up, because the exemption originally said that the mayor and the police chief are in total control over whether body cam video is released. Now, in use of force cases, it has to be released within, I think it's 5 days. But they still redact.
5 business days after discovery.
And they still redact. And so, I mean, but this is more generally about law enforcement exemption. And I think there is no need to expand what isn't disclosed under that. The privacy exemption, both the generic privacy exemption and the law enforcement privacy exemption are perfectly ample to address those issues. And if there's a dispute about it, then they end up in court.
Does anyone know or have experience? Is this the same issue? Do they have this at the fire, like FEMS? Is there issues with that as well?
I have no idea. I've never heard of it, but I have no idea.
I'll look
I
over,
haven't
because
heard of any.
what was that? I'm sorry, Helen.
I said I haven't heard of any, and I work for the deputy mayor for public safety, so both of those are our agencies, and I hear about complaints about MPDs, FOIA all the time, and not about FEMS.
Okay, yeah, I was just wondering.
I don't believe we have body cams on our firefighters, do we?
No.
Yeah,
no, we
that's
don't.
the difference.
Nor do we have cameras on the ambulances or fire engines.
Right, but this is generally law enforcement. This isn't specifically the body cams we started off talking about.
Yeah,
the body cams are
I think just
the most graphic issue, probably. But MPD operates on a presumption of secrecy rather than a presumption of openness.
I think that's a fair opinion, Bob. That's something, and I assume they had good intentions in doing it, but maybe, in certain things, like even that I do, like in my personal life, I'll just I won't mention any of it, because like one little part is actually good, so I just won't say anything. So I understand that, and that is something we should put towards really fleshing out and talking about in our next round. And I'm sure maybe their FOP has issues with it, and I don't know a lot about that. I don't think there's I wouldn't say, I don't have anything responsibility, but we hope there's no nefarious intent. It's just everyone doesn't want to get in trouble and starts redacting everything. I don't know. But that is something we should look at. I will say we have the longest list of, FOIA appeals in my office and my day job at the MULC, and they're usually from MPD. So we're going to be addressing those as well shortly. But I think this is a good thing to kind of start with. I know it's probably a lot very controversial, and there's political opinions about it, but that's not really important here. I mean, we just have to kind of follow open government and what we think it should be in the district. This is, oh, here's something I put in here, and like, I totally don't know why I put it in there, but we talked about it the last time. The circumstances for agencies to invoke the 10-day extension, because I thought everybody just always invokes it. And we,
In fact, that's, a few days ago, I made a request for records to DCRA. And because the request included emails, I got back a response almost within, I made the request in the afternoon the next morning saying, because we have to ask Octo for the emails, we are entitled to the 10 days. There's a presumption on the part of agencies that if they have to go to another agency, they are entitled to the 10 days. I don't think the statute says that, because the other agency could very well respond quickly.
Yeah,
but
I think,
there's
yeah.
an assumption on the part of FOI officers that if they've got to ask somebody else for any reason, that they get the 10 days.
I think that's practical, because in us working and what we do in the agencies, it's not like we're throwing in the towel, but you have to factor that in, because if you're getting emails, you have to have a proper search, you put it in ESR. And I mean, we put Stephen on the spot last week about like priority and how they search, there's all kinds of litigation, and I don't know how the magic computer machine works in pulling them all, and then they have to review them. So, I mean, I think that's practical, but if we add the extra days.
Yeah, if the situation warrants it, then you say, okay, this is why we need the 10 days. But I don't think the statute certainly doesn't presume that. The statute says that it may be necessary. This is one of the reasons we may need to have extra days. Not, this is a reason we absolutely have to have extra days. And
I think that may end up being a distinction in wording, but not reality. Just from the practical background of processing these, it is virtually, it is already a organizational challenge to keep track of things coming in, flowing out, what's at Octo, what's coming back from Octo but needs review, what's been reviewed but needs redaction, what's going to redaction but needs to go out. And I think given that my experience has been that 99% of requests that have to go to Octo are going to require that 10 days. Is it really worth the added administrative tracking if 99 times out of 100, the 10 days is necessary?
Well, but you're assuming that the only place this happens is when you have to go to Octo. And there are other requests for which an agency may have to go to another agency that's not Octo.
That's fair. I think that those are the number that require Octo cooperation for emails, in my experience, dwarfs the number that require other agency consultations. So maybe
and there may be no reason the other agency may respond to the request from the first agency in a day. So you can't structure the whole thing because some of the requests or many of the requests go to Octo. You have to look at it in terms of requests across the government. And I don't think that you should just build the 10 days in because of Octo. And
sure, quite frankly,
I think that there should be. Yeah.
Sorry.
I think there should be a system by which an agency can, if the district had a modern information management system, agencies should be able to search for their own emails without having to go through Octo.
Okay, we'll put that on the list too, Bob. An entirely new system. But I mean, what Vanessa is saying, I know it's just, I mean, it's almost like I'm looking at this, the invoke the 10-day extension. It's the assuming government is slow extension. The wheels of government are just moving, but it is kind of practical and Yeah, we need to talk about that more, and I especially like both of your takes on it, and everybody else when you think about this in your free time. I'd like to know what everybody else would think. I remember also we talked about the record retentions, and I'm sorry, Earl.
Quick question. Adding the 10 days. So if the process is going, when should the 10 days be requested? Like coming to 1 day before, 2 days before? I mean, so if you want to add the 10 days, what is the policy? You come down, oh gosh, tomorrow morning it's due. We got to extend 10 days. Shouldn't it be added then, not before?
Doesn't that get everybody mad?
Yeah,
Won't that make?
let me suggest something else, and using my request to DCRA again as an example. Most of the records I'm asking for, DCRA should be able to provide without going to Octo. So why can't it be required to give me the records that it has in its possession within the 20 days or 15 days or 20 days if we change it, and then say to me, okay, we need 10 more days to get the stuff from Octo that you want?
That's our practice. I mean, we do try to provide rolling production so that we at least make a down payment in terms of what's been requested, but while we're waiting for Octo. But there's no question our reality is that because of the high volume of requests to Octo, we simply get in line and wait. And that's more often than not, that's a reason why we request the 10-day extension. As soon as we realize that we need it, and we do try to let the requester know as soon as possible, as opposed to near the end of the statutory time, so that to help the requester understand sort of where we are in the process.
And
I can
Octo.
say,
Yep.
I'm
Go
sorry.
ahead. Go ahead.
I was gonna say it, to me that sounds like it's good faith. If in the process, I'm trying to find a balance between both. It's in good faith to say you're going to run the process, run the 15 days, 20 days, and somewhere along the process you come back and say, hey, it looks like we got all of this for you. Unfortunately, well, it looks like we'll need 10 more days, perhaps, and then so the requester can understand, oh, okay, that makes sense. Or they can get upset or get mad, but on my reasoning would be, at least there's communication back and forth, not automatically assuming you need 10 days, automatically you get it, and then you just toss it to the customer. To me, that sounds like you're just like, why are you putting 10 days? Because I don't know your process if I'm requesting, right? So why should you say it's going to take 10 more days? Then it requires an argument. Well, because
Right.
this.
I mean, DCRA is assuming basically told me you're not going to get the records for 25 business days, effectively almost a month and a half, because part of your request is for emails.
I mean, I think maybe a lot of this could be avoided with just communication between the requester and the FOIA officer. I mean, I think the one time I actually did one and it was like just me handling it. It was a humongous request. I sent a screenshot of my request to Octo and the search terms and the email boxes and said and they could see that I submitted this on whatever day. And anytime there was an update or if I asked for rolling, I would just let them know. And I think that's part of the good faith. I don't know what everyday FOIA officers do, if that's something you can do. I think if there's a lot of communication, I don't see people getting upset as much. I mean, I like it, but.
Yeah, I mean, I think from the FOIA offices that I've worked in's perspective, it's not so much that there isn't a desire to communicate, it's that the sheer volume makes it difficult to give each requester that level of communication. I'm not saying that's right or wrong, or that
No, get it.
there's not other things at play, but I think in every FOIA officer I know's experience, they want to be able to do that, and it's for some reason or various reasons not often possible.
Earl, did you want to jump in?
Yes. I know for like, I work on the federal government side. So I do know on that side of the house, there are people who are tasked in addition to do this, the FOIA process. So they're doing other duties in addition to trying to gather information sometimes. So is it in each agency you have, like you say, a group of people dedicated to do it so they don't feel overwhelmed? Oh, since I got so much time I don't have enough time to gather this information. And the systems are in play, like he's suggesting. You got a system that you can directly go in, pull emails, as opposed to coming out of your agency, go into another agency. So the process could take longer, but at the same time, it can be frustrating for the requester. Like I say, they don't understand the process internally, but the internal process, what really needs to be fixed.
Yes.
Yeah, absolutely. I mean, I agree. There's the multi-step process is challenging. To your question, Earl, about who handles FOIAs in different agencies, my understanding, and others can weigh in, is from my experience, it varies. Some agencies have dedicated FOIA folks, and then some, like EOM, it is part of a portfolio of duties.
Earl?
And I do it for 2 agencies.
So
along with other duties.
So I would suggest that could be from looking, my recommendation would be to consider hiring folks within agencies or a team that's dedicated and not creating additional duties, which would then eliminate the idea of having to have a 10-day extension because you have people dedicated to do the task as not overlapping other folks who have other responsibilities. And so they feel overwhelmed. And I remember I was working in another agency and this person was doing travel, was doing FOIA, and it was so much duties and doing mail, and there was so many additional duties. And then she would come into my office and says, I'm so overwhelmed, just at the federal side. And I'm like, wow, all these duties, and then coming downstairs into the office, and she has all this thing that need to be crossed off and like highlight off, and we can't release this, and she's trying to work with other people to get it approved because she's in charge to release the information. She can't release it until someone sign off on it. So these are all the process internally that's creating these extensions for 10 days, and the requester is getting frustrated because they don't understand the internal process. I'll say the internal process is really what we need to focus on, really trying to fix. So the requester could feel like, wow, this is smooth.
No, I hear you. Now this is all like practical, like our reality here. So the last one I put down was new district record retention policy. Maybe I should say that and then have the record retention policy, or know what it is, or different agencies. So we're going to put that for the next one, and that'll be something we can have a little group and talk about. So I wanted to, first of all, I really want to thank all of you for your time, your participation, your patience with us. I really am I never thought I would enjoy this because I was like so nervous, and I know literally nothing about FOIA. So I think we're really moving along. So the assignment and homework everyone's going to have is, so we're going to take off for August because it's August.
Because it's August.
That's, I don't know what else to say. And then we'll schedule like maybe mid-September. Julia, she'll send it out, and if you could let her know if this doesn't work, because we want to get the most people and the most opinions. But between that, when you're having like free time in the south of France, if you want to look at what I've drafted and just put in your comments or your feelings or your, cross it out, just do whatever and send it back to Julia. And then we'll just put them all together and see what we can put together for our first advisory opinion, and then we'll get serious when we start doing, we can spend more time on others. Does that sound okay?
Madam
Mhm.
Chair, I'm sorry to interrupt you. So we, when we updated the invite last night and recirculated it as a reminder, we did put a copy, of the
Oh,
draft in that.
okay, great.
However, I can also send a freestanding email, if that works better for folks, because what I sent out last night was a PDF. And if it works better for folks to receive a Word document as opposed to
Yes.
PDF to make
Yes.
edits, I
Thank
can
you.
do that too. So
Yeah.
I'll send that out today by COB. Just, and it won't be in the invite. It'll be a freestanding email from me on behalf of the chair. So that sounds like the common consensus.
Yeah, that would be really helpful. Oh, Earl,
Is your hand still up, Earl?
tell us something else, Earl. Yeah, okay, you just want to wave.
No, my hand is down.
So let's give that a shot. And just because I do have to pretend I'm a lawyer, I didn't even think about this before, but so I'm a deputy director at the Mayor's Office of Legal Counsel. Vanessa's deputy director of the Executive Office of the Mayor, Deputy General Counsel. What we say and do in these meetings are like our feelings, opinions, thoughts as regular district residents. It doesn't reflect at this point what the mayor, MPD, or anybody else thinks. And so is this draft, just so you know, because I don't want anybody pulling this up in litigation and saying the mayor's lawyer said this, or, you know.
You
blah,
should
blah,
have told
blah.
us that before you started.
You know what, whatever, just file it. Yeah, I don't care. You're not
It's
somebody
in the
until you get
recording,
sued around
Bob.
here.
We're counting it.
Yeah. It's Vanessa Natali, so, you know, just serve it on me, it's fine. But thank you, Bob. Additionally, when we get back, we are gonna set up a happy hour, and first round will be on me, but I'm really enjoying it. If anybody comes across anything or thoughts or prayers, send them over to Julia, and you know, we'll put it all together and we'll send you the invite out for like mid-September. Does that sound okay?
Yep.
Sounds great.
And thank you, everyone. I really appreciate your time. Have a good rest of the summer, and we'll see you after school starts. Not for me though, but no school. Okay.
Sounds good.
Okay.
Okay.
So Vanessa,
Thank you.
I'm
It
sorry.
is apparently
Yes.
1:59. What else do I say, Julia? And I'm closing,
Yeah, and that this meeting is officially adjourned.
and it's officially adjourned. Thank you, everyone. I appreciate it so much. Thanks for jumping on, everyone. Megan, you're
All right.
stuck with us now. Okay. Yeah. All right.
Okay.
Bye, guys.
Take care, everybody. Bye-bye.
Thank you.